time. I really appreciate everybody jumping on today. I see folks from California and Italy and all throughout Prince George's County. So I really appreciate you all joining us today. You're going to get a recorded session of this program. So I guess next slide, please. Basically, you should know that we have a partnership with Lerch Early Brewer. We're going to tell you a little bit more about that in just a moment. But my name is Alicia Moran, and I'm the manager of small business development here at Prince George's County Economic Development Corporation. We have two wonderful speakers with us from Lerch Early Brewer today who are going to go over different aspects of employment law and managing your employees, from everything from hiring and so on and so forth. So I just wanted to give you a quick update. This session is being recorded, so please just be aware of that. We are going to give you some information after the event. You're going to get a copy from Scott and Lerch Early Brewer with the link as well as the PowerPoint presentation. Next slide, please. So we're really pleased, as I mentioned, I work with Innovation Station, our business incubator in Prince George's County that's associated with our economic development agency. And we were pleased to partner with Lerch Early Brewer, a law firm with an extensive and wide range of experience and expertise to assist companies. We've done sessions on buying and selling a business. We did a session on company formation, and now we're going to be addressing managing employees. And in February, we're going to be doing a session on contracts and different contract law aspects, as well as maybe some aspects of some other areas, whether that's, landlord contract agreements, etc. So just know that this has been a really tremendous resource to our economic development agency. And in addition to providing these types of programs, there are also some open hours that we have been able to work with Lerch Early Brewer to actually assist our companies one-on-one. So next slide, please. Again, that's me. My email's on there. You all, I'll put it in the chat as well if you should need to reach me. Next slide, please. Go ahead, Scott, to the next slide. There you go. So small business services. So basically we provide a host of small business services, everything from training and workshops like you're having today to accessing finances. So you may be a startup, you may need angel money. We may connect you to Dingman Angels. You may need a bank loan. You may be looking to expand your business or start your business, or whatever else it may be. If you're in need of financing to buy equipment, etc., we would connect you to different financing resources. We work in partnership with a host of resource partners, which you'll see shortly. Innovation Station is our collaborative co-working space. You can see behind me our environment. This is our open co-working area to Innovation Station. We have small office suites, small and large office suites, as well as a remote situation. So if you're looking to have a virtual tenancy with us, we're here to help you and help you get to the next step. We have connections to other incubators and accelerators throughout and innovation hubs throughout the county, as well as across the state of Maryland. We work with companies that are trying to select a site, or maybe you need permit assistance. Say you're trying to get your use and occupancy permit and you have a question or you've gotten stuck somewhere. We'll work with the permitting department along with our partners over there. We also will work with you to help you identify possible locations for your business. We provide connections to international experts and industry expertise, and we offer coaching, counseling, and other assistance. So just know that, whether you're in Prince George's County or Montgomery County or Anne Arundel County, every county has an economic development agency. We try to work collaboratively to help our businesses. We know many businesses may have more than one location, so you may have, an operation in multiple counties. And so we're here to assist you. Next slide, please. So again, this is just some of the small business resources that we may connect you to. So whether you're trying to do government contracting and you need to get certification for MBE certification, or whether you're trying to register your business, or whether, again, you're looking to get financing, we can work with you wherever you are in the spectrum. We also work with small companies and have, again, SCORE is one of our key partners, and we work with them closely. Next slide, please. So Innovation Station, our incubator, is all about supporting our economic development mission of job creation, business retention, business expansion, and business attraction. And as I mentioned, we do have some international companies in our business incubator because it is an international soft landing pad. Next slide, please. So we have a host of programs that are out there to help small businesses. I'd point you to two right now. Emerge Stronger is still up and running. We have counseling sessions for those COVID impacted companies. You can go to emergestrongerpgc.com and register for a counseling session from 1 to 4 on Monday. You get seen with 6 counselors and you. And so people have finance, marketing, business operation experience, and it's really about trying to help you succeed. The Buy Prince George's campaign is a campaign that we put together with our partners in the county to support local businesses and to have you buy from local businesses. We also have a Spanish speaker on our team who deals specifically with our Latino community. We have Takeout Tuesdays, which is a feature of local restaurants. Next slide, please. So right now, that's a good segue. We still have our Restaurant Resiliency Fund up and running right now. And that is, so if you know anybody that's in the restaurant space and looking for, grants because they've been impacted by COVID, this opportunity still exists in the county. So please have a look. Next slide. I would also mention that, as many of you have already heard, the SBA has also, Congress has passed certain legislation, and so there's new money into certain funds. So the SBA has the Economic Injury Disaster Loan, EIDL grant, that and loan, that has now reopened. So if anybody didn't get to that the first time around and needs assistance, please make use of that. There's also the Paycheck Protection Program, which again is a second iteration. Some may have gotten money the first time, others may not have. So please know that that program, you go through your local bank or a lending institution. If anybody has questions about that, you can email me after and I'm happy to assist you. Next slide. And again, without further ado, you're really not here to hear me, but I wanted to just give you a little bit of background about Prince George's County Economic Development Corporation, Innovation Station, and our small business services. So I'd like to introduce our presenter. We have 2 presenters, and I'm very excited to have both of them here. We're going to start with Michael McNerney, and I'm going to let Michael do the introduction of his colleague. So Michael, without further ado, I'd like to turn it over to you. I'm sorry, Neary.
No problem.
I have a friend, McNerney. I'm sorry. So Michael Neary, my apologies. I don't know. I just make you Irish.
Yeah, that's fine. I'm Irish through and through, so appreciate it.
Okay.
Thank you, Alicia,
Okay.
and good afternoon, everybody. Thank you all for joining us. My colleague, Nida Kanwal, and I are delighted to spend this time with you today. Frequently in our practices, we start working with young companies when the first sign of employee trouble arises. And I can't tell you how many times I've sat with a business leader faced with a lawsuit or a claim, and they've told me they wish they knew all the landmines that were out there that they walked right into when they first started bringing on employees, so they could have avoided the situation that brought them into our offices before COVID, when we were actually in the office, that brought them into our offices. So our hope is that this presentation today will help you understand what some of the landmines that you should avoid or how to manage as you bring employees on and you ramp up and hire, and to help you manage, your biggest asset, but also your biggest liability, your employees. A bit of a roadmap here for what's going to happen today. Next slide. I'll talk briefly about the hiring process, how to bring employees on board lawfully, and how to document the terms of employment. And I'll then turn things over to Nida, who will provide some best practices for your employment policies and touch on the tricky employee independent contractor issue that many small startup businesses face, and discuss ways to protect your intellectual property and trade secrets. I'll then finish things off with a discussion of workplace health and safety issues, which has been all the more important recently with COVID-19 and the related issues surrounding that. And then to discuss briefly some insurance considerations you should take into account, and also some employee benefit issues. As we go along, feel free to use the chat or the raise hand button. We'll try to address questions along the way. We're happy to have a conversation if that's more helpful. Or, if we can't fit in the answers, we'll work them in towards the end, as there'll be a question and answer session. So first, starting off with the hiring process and the accompanying risks. Just kind of talk about, when you're talking about hiring, you really think about the beginning to the end. The first step in that process is traditionally you identify a need. You figure out that you've got some task that you need to bring somebody along to do. You advertise for the position, you receive applications, you screen the applications, you bring in your top candidates for an interview, you check references, and you hire them. What could go wrong, right? Well, unfortunately, at every step of the way, there's liability risks. You could have, a discrimination claim arise just based on the advertisement that you put out there. So you really need to be mindful of the risks associated with each stage of the hiring process. Typically, the biggest risks that I see are discrimination, retaliation risks. So there's multiple laws, federal, state, and local, that prohibit employment decisions from being made based on race, gender, disability, age, family status, marital status, and the list goes on, and it seems to grow every year. There's also liability that can arise from asking about someone's salary history. In Maryland, you can't ask about someone's salary history now. That's a new law that went into effect late last year. And there's liability that can arise from improperly checking someone's criminal background history. And also self-medicating, looking on social media to screen out applicants can also create liability. So how do you minimize the risk? And Scott, you can go on to the next slide and keep going there. How can you minimize the risk from this? I think first and foremost, what you want to do is you want to really think through the position that you're hiring for. You'd want to set forth and figure out what are the essential functions of this job? What are the main duties of this job? Why are you hiring somebody, and what are they going to do? You want to write that down in a job description. And if there's any physical limitations, you want to put those in the job descriptions as well. And it's very important to have that documented, because if an employee claim is filed later, if someone says, I didn't get the job for discriminatory reasons, it could be months before you even learn about that. It could be many months in some circumstances. So you need to be able to document along the way to justify your hiring decisions. And if you have a written job description, the criteria you use to select your candidate will be helpful to defend against a claim if it is filed. If someone says it was a discriminatory reason, you discriminated against me because of my disability, you didn't hire me for the job, you can point to a job description if there are physical requirements that the individual was not qualified for, even without some sort of an accommodation. That's a justifiable employment decision. You want to set salary ranges for your positions in advance. This helps minimize the chance that when you do bring somebody on board, you will have inadvertently paid man more than a woman. It will also help you in your negotiating process, so you can make concessions where appropriate in line with your hiring criteria or your salary range. It's also a new requirement in the Maryland salary history ban. Look at your employment applications to the extent they're using them to make sure that they're not asking about criminal history. You don't want to ask about criminal history until at least the initial interview. When you have an interview with the candidate, after that, in most jurisdictions in Maryland, you can start inquiring about criminal history. In Montgomery County, they've passed a recent law indicating you can't ask about criminal history until you make a conditional job offer. And I think the biggest thing people can get in trouble with is the interview itself. Most places don't really understand that you want to have a structured interview process to minimize legal risk. You don't want to just have an interviewer go in there and wing it. And I see this even in my own law firm when we interview candidates. It's human nature to want to engage in a conversation and start talking about all manner of a person's personal life. If you start asking questions about family responsibility, about someone's religion or national origin, you can find yourself in creating a circumstance where an individual who doesn't get the job might look back and say, that was really weird. That person was asking me all about my faith or asking me all about where I came from. And maybe that's why I didn't get this job. I know I'm super qualified. So you want to be training your interviewers on the fact that there are legal risks. I would recommend you have a set standard of questions that you ask each candidate. That will prevent ad-libbing during the interview process. You want to focus your questions on work history, the candidate's strengths and weaknesses, prior work challenges, how they overcame those challenges, what they learned from past failures, focusing really on their educational and work history are good, and really trying to determine what my colleague calls grit. You want those candidates who are going to overcome challenges and not shrink from them. And my final kind of piece of advice to minimize risk during the hiring process is you want to be able to explain why you picked one candidate over the other. Because again, those employment claims could come much later down the road. So for instance, if you selected candidate A over candidate B, and candidate A had superior credentials on paper, you can justify that pretty easily later. But what if you liked candidate B and they had lesser credentials? Maybe they had a lower GPA, or they had less work history, or they didn't go to such a fancy school. Why did you pick B over A? It might be hard to explain that later if A filed a claim of discrimination. So I would advise that your interviewers not only have a set standard of questions that they ask, but some sort of a form documenting their impressions of that interview. It could be on a 1 to 5 basis, but just to be able to, in the moment, capture why they like that candidate or what that candidate did to give them pause. And that will well position you if you do find yourself in the unfortunate circumstance of having an employment claim filed later. So just briefly, you find your candidate, you want to bring them on board. And if this is your new hire, your first new hire, the next slide will really talk about kind of some items that you probably might not have thought about. If you've already got employees, this might be old hat for you, but you need to be registering. You need to have an employer identification number with the IRS. You need to be collecting tax forms from the individuals that you're bringing on, the W-4 form from the federal level and the state forms. And importantly, you need to be registering with the Maryland New Hire Registry. This is an actual website you can go to and log on your new hires. And the state captures that information because there are potential child support obligations that could come about that you as an employer would have to withhold from pay. Similarly, they want that information for workers' compensation issues and unemployment insurance issues that we'll talk about a bit later. But just wanted to flag that you need to be actually telling the state when you're bringing on somebody new or you're rehiring somebody. There is also some immigration considerations that you need to be mindful of. Employees have to be lawfully allowed to work in the country, and you identify that through the I-9 process. You want to have your employees fill out the I-9 paperwork appropriately, and you want to keep and capture the supporting documentation. This is a hot area of audits, so you want to start good practices now, because the bigger you get, the greater risk of an audit. So you want to capture the I-9 and copies of the documents. And if you're looking to hire foreign workers, you really should consider consulting with immigration counsel. We're not immigration lawyers here at Lerch Early, but we have strong relationships with immigration lawyers that specialize in the area, and we can make referrals as needed. But bringing on foreign workers is a really complicated area. You need to make sure that you're doing it right and you're getting the proper documentation in place. And a good immigration counsel can help advise you along the way. And so once you've kind of jumped through all these hurdles, you found your candidate, you've got the appropriate paperwork, how are you going to document this with your workers? I'm handling a case right now where an employee was brought on board and they didn't document it. And the employee thought they were going to get $15 an hour when the employer thought they were only offering them $12 an hour. And this is now a regulatory matter before the state of Maryland. And it's a costly matter. And I asked the first question, I said, well, can I see the offer letter? Can I see the contract? Oh, we don't have that, Mike. Sorry about that. We're fine, right? Well, yeah, who's going to tell the story that it was a $15 an hour position? Oh, well, that person's no longer with us anymore. Now it's becoming a lot harder to defend that case. So you need to document what the terms and conditions of the job are. And you can do that in one of two ways. You can have an offer letter, which most employees have, or you can have a contract. Typically, contracts are for higher level, high skill employees who are in high demand. And an offer letter is for most other people. The key to an offer letter is you want to make sure that you're having an at-will employment arrangement, meaning you can fire them for any lawful reason. Or they can leave you for any reason. They can take another job at any time. But you don't want to be committing to them for a set period of time, because then you can only fire the individual for cause. So in your offer letter, you also want to set forth compensation. You want to set the rate of pay. You want to decide whether this position is exempt or non-exempt. That means whether they're entitled to overtime or not. And Nida will talk about that further. But it needs to go in your offer letter. You need to make that decision on the front end. And you need to tell them about it in your offer letter. You want to set forth your pay days, what the duties of the position are, who they're going to report to, what their hours are going to be, and what the start date is. And if there's any benefits you're going to provide, you want to put that in the offer letter as well. But you want to be mindful that you don't want to make promises. You want to reserve the right to change benefits later. And finally, if there's any conditions to the offer, you want to put those in your offer letter. For instance, you can't hire them if they're not authorized to work in the United States. So you want to condition the offer on satisfactorily completing the I-9. Or if there's any background checks, you want to say that they have to satisfactorily complete that as well. Now, another condition that can go in an offer letter is if you're going to have a restrictive covenant, a non-compete or a non-solicitation, which Nida will talk about here shortly. You want to set that forth in the offer letter. A contract does much of the same stuff, but it also typically has a set period of employment. So there's a start date and an end date. It's a 2-year contract. And you see that a lot in sports, right? It's a 4-year contract. There's a beginning and an end. We can fire you, if you do something for cause that we'll define in the contract. But you can't just get rid of somebody on an at-will basis if they have an employment contract. Another issue that kind of emerging businesses face is how to deal with compensation and equity with a new hire, maybe one of the founders or one of the early adopters, someone who came on board early. And this, you really need to give a lot of special consideration to this. I've seen a lot of matters that turn to litigation when there's money to fight about. And it usually arises because the expectations aren't set in the beginning. Promises are made, more promises. One side thought the promise was better than the other. This is really an instance where you don't want to pull a form off the internet. You want to be sure to give care to the document that's going to give someone equity in your company. Excuse me. So there's alternative ways. Rather than granting someone equity, if you want to give somebody compensation, maybe you give them a profits interest, you give them a percentage of profits without necessarily giving them equity in the company. And I would say that the more equity you promise to others, the harder it's going to be to raise funds later, because investors are going to want to come in there and look for what the upside is for them. So give thought to ways other than just equity that you can give someone an opportunity to come in at a lower pay rate, because you want to keep your labor costs low in the beginning, obviously, and have them have an upside. But the default seems to be equity positions. And I just would caution you to give a lot of care to that, because it can really get bad quickly once there's money to fight about, which we all hope we're going to get to as we develop our businesses. So I covered a lot there. Went pretty quick. Any questions, throw them in the chat and we can address them along the way. But, you know, I'm turning it over to Nida here to talk about some best practices with employer policies. And Nida is a fantastic colleague of mine. She went to University of Maryland and University of Baltimore Law School, where she won numerous awards and went on to clerk for the Court of Appeals of Maryland, the highest court in Maryland. So turn it over to Nida.
Thank you, Mike. Good afternoon. So I also have a lot to go over. I'm going to do my best to get through it all. So I'm going to go over first some basic practices and policies to implement and to include in an employee handbook or manual. So the first policy I'll go over is the at-will employment policy. You can go to the next slide, Scott. So this basically just makes it clear to employers or to employees that employers reserve the right to terminate employees at any time, and that employees may also voluntarily leave employment. Mike already touched on this, but this policy basically reserves that right in the handbook and also provides that the handbook is not a contract. So an employer is not bound by what's contained in the handbook. The next policy is the Equal Employment and Anti-Discrimination Law policy. Again, Mike kind of went over this, but basically avoiding employment discrimination liability requires sensitivity to a variety of protected classes, which I have listed here on the slide for you. And having a handbook policy in place, it's helpful to point to if there is a claim of discrimination, to evidence the company's commitment to anti-discrimination, and also outline a complaint procedure for employees who feel that they've been subjected to discrimination, and it sets a tone for diversity in the workplace. Next is the Anti-Harassment and Anti-Retaliation policy. So these policies help demonstrate that there was reasonable care to prevent and promptly correct any harassing behavior in the workplace. And that's actually a necessary defense, which is available in the event that there is a hostile work environment harassment claim. And many state and federal statutes regulating the employment relationship also prohibit employee or employer retaliation, which basically means taking adverse action against an employee who's engaging in some type of protected activity, such as making like an internal complaint or filing charges or a lawsuit. And employees with a good faith belief in making their complaint can prevail in these types of retaliation claims, even if their underlying complaint is meritless. So for these reasons, businesses should consider implementing a strong anti-retaliation policy, communicating that to all of its employees, and training employees, particularly supervisors, on the meaning and impact of that policy. Next is disability and religious accommodation policies. So the ADA, which is the Americans with Disabilities Act, it prohibits employers from discriminating against qualified individuals because of their disability. And it requires employers to provide a reasonable accommodation to an individual with a disability, unless it would pose some type of undue hardship to the business. And once an employee requests an accommodation for a disability, the employer is required to engage in an interactive process with that individual and has to provide that accommodation, unless, of course, as I mentioned, there's an undue hardship. An employer should consider implementing this policy because it communicates the employer's commitment to the ADA or an applicable state law, and it informs employees of their right to request accommodations. And then businesses are also required to provide employees with a reasonable religious accommodation under Title VII. And employers should consider implementing this type of religious accommodation policy to create uniform standards and procedures for responding to requests for accommodation. Next is the sick leave, holiday, vacation, and paid time off policy. So private employers are typically not required by federal law to provide employees with paid holidays, vacation, or sick days. though many employers choose to do so anyway. However, there are state and local sick and safe leave laws, as well as a sick and safe leave law for federal contractors, which require employers to provide employees with protected leave for the various covered purposes under those laws. But if any type of leave is offered, employers should have a policy in place to inform employees of the designated paid holidays, the number of vacation and sick days, and how that time accrues, the policy for requesting time off, and notifying the employer if the employee needs to take the time off, whether vacation or sick time can be carried over to the next year, and whether the employee is going to pay out the leave at separation of employment. And some employers also choose to provide one paid time off PTO policy that can be used for multiple reasons: vacation, sick time, etc. Next is the family and medical leave policy. So under the FMLA, which is the Family and Medical Leave Act, employers with 50 or more employees have to offer unpaid family or medical leave to eligible employees for the various purposes that I have listed out here on the slide for you. But in order to be eligible to take the leave under the FMLA, an employee has to be working for a covered employer for 1,250 hours during the previous 12-month prior to taking the leave. They have to work at a location where 50 or more employees work, or at a location within 75 miles of that workplace. And for most purposes, FMLA leave extends for up to 12 weeks during an employer-specified 12-month period. But for leave to take care of a family member under military purposes is up to 26 weeks. Next is the social media, internet, email monitoring, and bring your own device policies. So some employers conduct electronic monitoring and surveillance of their employees to protect against employee misconduct, manage productivity, and increase workplace safety. Employers must comply with various overlapping laws, including privacy laws and employment laws, when conducting this type of surveillance. So to limit the liability, employers should enact a strong policy and consistently adhere to it. And that policy should provide notice to employees that there's no reasonable expectation of privacy in the use of their employer email or computer systems, explain the business purpose of the monitoring policy, such as the production of confidential information or trade secret information, prohibit electronic communications for any harassing, discriminatory, or retaliatory purpose, and restrict personal use of the employer's email and computer systems. And to craft an effective social media policy, an employer should carefully consider the purpose and objectives of the policy. So instrumental to that is kind of balancing the factors, including the employer's attitude towards social media use in the workplace, the nature of the employer's business, characteristics of the employees and the work environment, and legal restrictions on chilling concerted activity under the National Labor Relations Act, the NLRA. So if an employer does adopt a bring your own device to work policy, the BYOD, in the workplace, it should implement security measures to protect company data and confidentiality, clearly define the limits of an employee's expectation of privacy on their personal devices used for work purposes, identifying when the employer can access, monitor, wipe, or disable the employee's device, and what data or folders the employee is able to access, institute procedures for reporting lost or stolen devices, prohibit off-the-clock email use by exempt employee or non-exempt employees, excuse me, so that there's no overtime issues, clarify the policy for reimbursing employees for the cost of using their own devices for business purposes, specify procedures for deleting company data at separation of employment. And the next policy is the code of conduct, code of ethic, and conflict of interest policies. So a workplace conduct policy is not legally required, but it notifies employees about employer expectations for acceptable workplace activity. However, if corrective action at termination is required, a workplace policy, it gives the employer an objective basis for disciplining or terminating an employee who engaged in prohibited behavior based on this type of policy. And a code of ethics policy allows an employer to promote professionalism and raise awareness of potential conflicts of interest. The last policy I'll go over is the performance review and talent management. So periodic employee performance reviews can be a valuable tool to help employers improve performance of their employees and improve morale. Performance evaluations become important as the workforce begins to expand, and it's beneficial when used as a basis for employment decisions such as promotions or demotions, to improve the performance of underperforming employees, and to document employee progress at the company. But you should be sure to not poorly execute these performance reviews, because that can be a risk, a litigation risk. You want to make sure you're training your supervisors and managers to conduct these reviews efficiently and honestly. And you can consider evaluating employees' performances using specific criteria, which is also helpful. The next topic I'll go over is wage and hour issues. And the first subtopic under there is administering payroll. So before hiring any employees, the employer should determine who's going to be responsible for administering payroll, for example, like a CFO, an HR professional, or a payroll company. How much and in what manner the company will pay its employees, such as on an hourly basis, a salary basis, or maybe commission basis, or some type of combination of all of those. The pay frequency and cycle, which may be subject to minimum requirements under state or local law. Employers should be sure to communicate this information with their employees in an offer letter. An employer should also document their pay practices in some manner to avoid future disputes or liability under wage payment laws. Next, complying with minimum wage and overtime laws. So both federal and state laws impose strict requirements for the payment of minimum wage and overtime, unless the employer can demonstrate that the employee qualifies as an exempt employee under the Federal Fair Labor Standards Act, the FLSA, or the applicable state equivalent. I've listed here the requirements in Maryland for the minimum wage. And overtime is generally calculated at a rate of 1.5 times the employee's regular rate of pay for all hours worked over 40 hours in a work week. Next, classifying workers as exempt or non-exempt. Under the FLSA, employers must pay covered employees with at least the minimum wage. Employees must also receive overtime payments for worked hours over 40, as I just mentioned, unless they qualify for one of these exemptions that I have listed out here on the slide. And to qualify as an administrative, executive, professional, highly compensated, or computer professional employee under federal law, employees must meet both, one, the applicable exempt duties test, meaning that the employee must spend a sufficient amount of time performing the duties that qualify the employee as being exempt, and two, the salary basis requirement. And an employer pays an employee on a salary basis under the FLSA if, one, the employee receives a predetermined salary each pay period that isn't subject to reduction based on the quality or quantity of work performed, and two, the salary meets or exceeds the predetermined salary threshold. Effective January 1st, 2020, the minimum salary threshold was at least $684 per week, or $35,658 annually, and $107,432 annually for highly compensated executives. Next, independent contractors and the risk of misclassification.
Real quick, Nida,
Yes.
we have some questions coming in. If everybody could kind of sit tight, we're almost to the question and answer time anyway. So we'll wait 5 or 10 minutes, and then we'll start ticking off the questions after Mike and Nida kind of tie up the slides.
Sounds
So,
great. Yes, sorry, I know there's a lot of information to cover.
so we'll get to the Q&A in a little bit here. All right, Nida, sorry about that.
Great, no problem. Next is independent contractors and the risk of misclassification. So there are several tests used to determine whether independent contractors are properly classified. There are different rules under various laws, including the FLSA, as I mentioned, the IRS, and then also workers' comp and unemployment at the state and local levels. But the takeaway is basically that it's a very challenging and an individualized analysis. And classification lawsuits are costly to defend, and they can potentially disrupt or destroy a company's business because these suits often result in settlement payments in the millions. Next, improper reliance on unpaid interns. So the Department of Labor, the DOL, has adopted a 6-part test for analyzing internship status. However, some circuit courts, depending on which state you're in, they have varied tests, and some reject the DOL's test altogether. So although these tests do vary, before retaining unpaid interns, businesses should consider some of the factors here, which include, whether the intern is receiving academic credit, whether the intern is doing work that otherwise would be performed by employees, or the same work as other employees are performing, and the degree of training provided to the intern. So the next topic I'll cover is protecting intellectual property and goodwill. So businesses invest significant resources in developing proprietary products and services, marketing strategies, customer goodwill. And to protect these assets, employers should explore various mechanisms, including requiring employees to sign agreements governing confidentiality, non-solicitation, and non-competition. So the first one is confidentiality and proprietary rights agreements. Go to the next slide. Many employers require their employees to sign confidentiality and proprietary rights agreements to protect their valuable confidential information and also their intellectual property assets, including trade secrets from disclosure or misuse by an employee. Next, we have non-compete agreements, and these are agreements between an employer and an employee that restricts a former employee from working for the employer's competitors for a specified period of time after that employee's employment ends. Non-competes can be a useful tool to protect employers' corporate assets, such as trade secrets and goodwill. I should mention that in Maryland and in Virginia, there has been recent legislation which prohibits non-compete agreements for low-wage workers. And for Maryland, that applies to workers with wages equal to or less than $15 per hour or $31,200 annually. And in DC, a law will likely become effective next month, prohibiting non-competes for almost all DC workers. Next is non-solicitation agreements. So a non-solicitation agreement that basically prohibits an employee either during or after employment or both from approaching the employer's other employees, clients, customers, vendors, or business partners to attempt to hire them, retain them, or create contractual relationships with them. Non-solicitation provisions typically prevent former employees from using confidential and trade secret information to solicit these other individuals, and indirectly protect trade secrets by limiting a former employee's freedom to raid company resources. So these are especially common for salespeople who have developed customer relationships and goodwill at the expense of their employers. So I'll turn it back over to Mike to cover the next topic. Thank you.
Thank you, Nida. Appreciate it. And just before I continue on, I'll just address some of these questions because some really great questions have come through. So the first question that came through was about criminal background checks. Basically, if the job requires a criminal background check, can you run a criminal background check? And the answer is yes. The law pretty much regulates now how you go about doing that. For instance, I mentioned earlier that you can't ask about criminal history until after you've had that initial contact, that initial interview with a candidate. And also, there's certain things that you cannot take into account from someone's criminal history. And so, for instance, charges, we never recommend taking into account charges alone, making an employment decision based on that, because it can lead to discrimination liability. So you really want to focus on the underlying facts. But the long and short of it is you can run someone's criminal background check, but you got to kind of follow the rules that the governments have set up along the way, which leads to one of the broader questions in here, which is, given all the depressing news we're giving you here this morning, and there's all these regulatory burdens, how is a small business with limited resources supposed to handle this? And what do we recommend? Well, I think you guys are all doing the right thing here, coming to this program. This is a good start. I also have seen successful businesses manage this by putting it on someone's plate, assigning it to someone within your team, or if it's just you, set aside some time to read broadly on these issues. We've started a blog at Lerch Early on employment issues. You can subscribe. We can get you the information about how to do that. And we try to write a couple times a month on new developing issues, or just issues that might not be top of mind. Subscribe to that or other blogs. There's tons of them out there. And set aside some time to just try to stay up to date. And also try to make good relationships with advisors, other colleagues or other people in your industry who have done it before. Find a good mentor, or link up with a lawyer who's willing to have a dialogue on these issues. That's willing to answer the phone without running the meter, just to kind of say, okay, this is an issue you need to focus on, which is a good thing to have as you grow. Someone asked for a little bit more about the 1099 employer question, which Nida touched on, pros and cons. There's a million tests out there about how to get it right. And basically it all comes back to control. In my view, if you're controlling the day-to-day of an individual, they're an employee. And if they can't go out and work somewhere else, or they can't, provide their service somewhere else, if they're not in there for the profit and loss like you are, they're in to punch a clock and earn a fee, they're an employee, and should be treated that way. Now, I get pushback all the time when I'm advising a company with 1 or 2 employees, who they've characterized as a contractor. Yeah, Mike, it's all well and good that you're going to tell me by the book, this is how you do it. But if I do it that way, I can't run this business. And I get it, right? You look at your Ubers and all these food delivery companies, they wouldn't exist if they couldn't do it as contractor basis. And, they've actually, they're being sued all the time over the issue, and they've got the resources to fight it. And they're losing some of these cases along the way. But I would say as you build your foundation, you want to be doing it right. And if you look at the issue and you're not doing it right, as you grow, it needs to be higher up on your priority list to change and get it right, because you're a bigger target as you continue to grow. So those are my 2 cents on that tricky issue. Somebody had a detailed question about not being able to ask health information during the interview process, and leading to 2 candidates that have caused a lot of trouble and cost. And how can they avoid that in the future? I recommend that when you have hires that haven't worked out or that have caused challenges, and also when you have hires that are knocking it out of the park, you need to stop and think, how did it go right and how did it go wrong? What did I ask during the process of the candidate that knocked it out of the park that I really should be asking for everybody? Or what intrigued me about that candidate that I should be asking about everyone? And try to continue to refine your interview questions, because you can't come out and ask those difficult questions about someone's mental health issues or physical limitations. That's just going to get you in a world of hot water. But there are questions that maybe you can come up with that would elicit whether this candidate is going to succeed or not. And so that's really my best advice on that, to continue to look at your organization and look how you're prospering or where your pitfalls are and learn from them. Reform your processes along the way, to continue to try to find those individuals who are going to overcome obstacles and exceed your expectations. So I think that's the best way to handle that. I think if a startup is not really making money to offer fixed salary, what other ways can you offer compensation? Can you offer employees a percentage of sales made? So you need to be compensating individuals, employees on at least the minimum wage. There's a narrow exception for individuals who have, I think it's over 10% ownership in the company. But absent that, individuals need to be getting at least the minimum wage. And you can incentivize somebody. So if you're bringing somebody in at a level where they, minimum wage is not going to appeal to them, percentage of profits might be an option. Commissions could be an option. There's all sort of ways you can have incentives built into their comp system to try to compensate them fairly, but you definitely need to be compensating them at least the minimum wage for all hours worked. So where we'll go here for the presentation is talk about safety issues and then some benefits concerns. Before I do that, just to address another question about whether it's discriminatory if a supervisor makes less than an employee that they supervise. No, not in and of itself. It's not discriminatory. You'd have to look at other factors because the level of the hierarchy within your business is not a protected class. But if there's a racial or religious or male-female difference, that could be the basis for the disability. So talk briefly. And I'll close out the questions here in a minute, but talk briefly about workplace safety issues. Workplace safety issues, most employers never really gave two thoughts about unless they were manufacturing or in an industry with heavy labor. But with COVID-19, workplace safety is top of mind to everybody right now. And that's really because there is a general duty under federal law to provide a reasonably safe working environment. And COVID-19 is a recognized threat to the workplace. And so if you are working in an office or if you're welcoming members of the public into your space, you need to make sure that you're taking steps to protect your employees from the spread of COVID-19. And that's why, you got to be following public health guidance. You want to be monitoring what's the latest guidance from the CDC or from your state or local officials. And continue to follow that guidance until you're told otherwise. Masking, social distancing, enhanced cleaning, all the stuff you've heard since March. It's important to do that because if spread happens in your work environment, you could be liable. So workplace safety needs to be top of mind. Just the final 2 points here really are insurance considerations. So there's laws on the books in Maryland to have workers' compensation policy. When you bring on an employee, you got to have a workers' compensation policy in place. You're going to pay into the unemployment system, but then you got to protect yourselves. Like those protect your employees. Workers' comp protects you because it insulates and protects you from claims if someone's injured on the job. Those claims go through the workers' compensation system. But you want to be thinking about directors and officers' liability coverage. If you have employees, as you grow, you certainly want to start thinking about an employment practices liability coverage because a general directors and officers policy or a general liability policy is not going to cover an employment claim. You usually have to buy an additional product. If you don't have a good insurance broker, you should find one. We have some recommendations just to help evaluate what you have and what you need, given the size of your business and the industry you're in. And finally, similar advice when you're talking about health benefits. If you're thinking about offering those, you really need to have a good health broker you work with, because you can do it wrong. There's discrimination testing for health benefits. A good insurance broker can help minimize those risks. And then finally, once you start offering health insurance, you're going to be getting a lot more health medical information. So just a word of caution that any health information that you do receive, you need to be keeping that in separate files from personnel records, and they need to be under lock and key, meaning only people with a need to know have access to it. And you certainly don't have to provide health benefits, but it's obviously a big draw if you're trying to attract and retain good talent. So certainly it's a good thing to offer if you can. So we're about at 1 o'clock, and we've got a couple more questions in here. So if you bear with me, I'll just review the questions that have come in, try to address them here. So is there a limitation on the amount of hours that an intern can work per week? So an intern, I just caution you to make sure that they're a true intern and not an actual, an employee. And the long and short of it is, if the intern is doing something that you would typically pay somebody to do, they're probably not an intern. Meaning, if you're displacing another worker, you might have a challenge there to uphold them as an intern. And the long and short of it is, the law was designed in a way to try to, politicians write the laws, and politicians want the unemployment rate low. So they write these laws narrowly to try to incentivize people to hire individuals and not just make them interns. So it's a really narrow window to walk through. But if they're true intern, no, there's not any sort of limit that I'm aware of. Discount insurance brokers or online HR services to manage your staff. Certainly, there's a lot of good products out there. There's some bad ones as well. I would do your due diligence if you're going to be considering a discount insurance broker or an HR service online. Just check references, ask to speak to some folks that have used them. I made this mistake once with moving company. I checked the first page of Google and it came back to bite me. So if you're doing your due diligence, make sure you get to the, far down the list of the Google page results, because you might get the true story. But certainly there's a lot of options out there to try to help you manage all the challenges that we've kind of flagged for you here this morning. And just make sure that you do your due diligence. So that is all we have here this morning. If there's any questions now, you can certainly unmute, or you can throw them through the chat. I know people probably might have to check out. That's fine, but we can certainly hang around for a little bit and answer questions as they come up.
You spoke about your blog. Maybe it's incorporated into the chat, but what is the name of it, or is there a link that you can incorporate in the chat, please?
Sure. We'll put it in the chat, but it's the Lerch Early Employment Edge is the name of it. And I'll figure out how to put it in the chat, or we can email it around with the slides.
Thank you, sir.
Mm-hmm.
This has been a great program. So just remember, this is your opportunity, everybody. You have a couple lawyers in front of you, able to kind of answer some questions. So if you have any additional questions, please chime in. Just either send along in the chat or otherwise. Marilyn?
Okay. At what point in the hiring process can you ask questions about someone's health status? I've had employees who were diabetic, and we, worked with them to make sure that we knew what to watch for if they were starting to get sick and who to call and that sort of a thing. It's but with mental health issues, it's somewhat different. And how do you go about doing that, or asking that kind of question that would lead to an answer so that you know how to best deal with the kinds of situations that could arise?
Great question. I think it starts with your job description and making sure that any physical limitations are identified in there so that individuals have an opportunity to ask for accommodations along the way. During the hiring process, unless there is a specific articulable physical requirement or mental requirement, I'm thinking, intelligence type positions, maybe if you're a federal contractor in the intelligence space, or if you're a firefighter or things like that, those are physical requirements of a job where you can have testing, perform, physical testing. Absent that, you really can't get into someone's health condition during the hiring process. Later on, if you hire the individual, if there's a business need to know, you can get into it in narrow circumstance. But it's really up to the interview process to set the conditions of the job, have the person an opportunity to ask for an accommodation if needed, but you don't want to be asking them about their health situation in the interview process.
Okay, so I have no way of protecting myself or my business or my other staff members from possible repercussions from a mental health issue as it starts to evolve after employment has begun.
So if you have if there's a threat in your workplace, you have ample opportunity to take immediate steps to protect yourself. And one of my key principles in advising clients is health and safety of my workforce or my clients' workforces are front and center. So I always would risk an employment claim over a health or over a safety issue at any day of the week. And so if you have an employee that's exhibiting conduct or behavior that is threatening to your work environment, you certainly can take steps to remove that threat from the work environment. But so you're not helpless to be able to protect folks. But in terms of trying to screen folks out, the law is designed to prevent you from doing that, because basically the law is designed to have people hired on the merits of their abilities, not on kind of fears and perceptions that, oh, everyone with mental health is a threat or everyone with diabetes is going to be a pain to deal with. And so it's really trying to exclude those inquiries from the hiring process. Mm-hmm. But certainly if there is a threat to your workforce, once you bring somebody on board, there are steps you can take to remove them from the workplace.
Okay.
Morning. I had a question. Can you hear me?
I can, yep.
So I'm starting up an animated film company, and I'm looking now at hiring people to help me with this, basically artists and animators. And the question I have is respect to intellectual property and protecting myself against persons who might take ideas, take products in terms of digital products. How do I protect myself from that? People who are working for me who might basically take the ideas that I have and leave and do something on their own or work with someone else.
Right. Great question. Nida, do you want to touch on that? Or I certainly have some thoughts, but.
Yeah, I think, having that confidentiality agreement in place to, make sure that all of your assets, your intellectual property is protected. In addition, you could have a non-compete agreement just to, limit whether when the employment relationship has separated, that will restrict the employer or the employee from, putting up like a competing business using your protected intellectual property, or working for a competitor for a certain amount of time. So those are just a few of the things. And then also there's like IP law that you can get into, making sure that you have your assets trademarked, copyright, all that kind of stuff.
Right. Yeah. And just to touch upon that, you can have an actual proprietary rights agreement where you make it clear whose work product, who it belongs to. So that if they're doing work for you, it belongs to your company. And so basically the answer to your question is that, there's a number of agreements that you can enter into with those individuals to ensure that they don't steal your great ideas for their own benefit.
So proprietary rights agreements and non-compete. Okay, all right, I got it. Thanks. One of the thing was, so I have several quote unquote digital assets. It's just having them all copyrighted is really, and patented, I guess, is really costly. Is there a way to do them all and just have like a bulk of them? Or would I have to do each individually? Like design?
Right. I think it is an individualized process, but that's kind of out of our wheelhouse. We're not intellectual property lawyers. Again, we can make connections for you, but my general understanding is it's an individualized idea or product that you're gaining rights to.
Yeah. All right. Thank you.
You got it. So there was a question on here about how to go about retaining an attorney for a business. Is it better to do as needed or monthly? For all lawyers have different agreements they're willing to undertake. I know with a lot of small businesses, what I try to do is engage with them. So have an agreement in place. Some clients will do an actual monthly retainer, particularly when they're small, so that they can budget and plan. Typically it's designed to allow freedom and flexibility for the client to call up and just say, hey, this is an issue. Should I be, I'm dealing with, there are legal ramifications for it. But I would advise to get a relationship going because when you need them, it's better to know and have that relationship in place than trying to scramble when it's an emergency.
Sir, just wanted to circle back on Pamela's earlier question in regards to the pros and cons about 1099 versus salary, and was hoping, do you mind if we just kind of go a little deeper into that? Is it, you mentioned that it's predicated on some of the rules that you have in mind for them, but we'd just like to get some more insight as to what are some other variables that you can use to determine which one's better from a risk, cost basis.
Sure. Okay. So the cost, I think the cost is universal. The 1099 is going to be cheaper to the business because you don't have to pay the employer portion of the FICA tax. So the employee and the employer split that when they're an employee, and so that's why businesses often try to create 1099 workers out of when they're really employees. So when I say the element of control is really the paramount factor, if you're engaging someone for a project and you say, I want you to paint my house, I'm going to pay you $1,000 to do it. That's the quintessential independent contractor. They can go paint the next door neighbor's house and you don't care when they do it. The further away from that type of a relationship you get, the more likely it is to be an employer-employee relationship. So for instance, if you yourself have a painting business and you have folks you engage to go paint houses. Well, are they in business for themselves? Like, do they paint for other people or just for you? How long is your relationship with them? Is it one job, or have you been working with them for 6 years and they really don't work for anybody else and they don't have their own business? Now you're talking about an employee. So I think those are the factors: the longevity or the control over the individual, setting, the terms and conditions of their work, show up here, do this, and this is how you do it. That's an employee. If they're not working for anybody else, it's even more a factor that they're an employee. If you say, I want you to do X, I don't care when you do it or how you do it, just do it, I'll pay you this. That's an independent contractor, generally. Is that helpful?
And what's the pros and cons with the unemployment versus an employee and an independent contractor?
I'm sorry, what are the pros and cons of the both?
Yes, we're concerning unemployment benefits.
Yeah, so if you're an independent contractor, you are in business for yourself. You suffer the profit or loss. So if you agree to paint that house for $1,000 and it costs you $1,200 to paint the house, you lose money. If you get hurt painting that house, you're not covered by workers' compensation. And if you get fired from that job, if they say you're doing a bad job, you're done, you're not going into the unemployment system. So all those things are not there. And typically you might find people wanting to work as an independent contractor when things are good. But if any of those things happen, they say, wait a minute, I was really an employee. I should have had unemployment insurance. I should have been covered by workers' comp. And that's where problems arise. So the pros are, the pros from the business side is it's lower cost for a 1099, but greater risk of an employment claim later. If you do it by an employee, if you set them up as an employee, you're minimizing risk of all those other issues happening. There is an added cost to you. It's the added cost of the FICA tax and plus the added insurance costs.
Well said, well understood now.
Okay. Okay.
All right.
I don't see any other questions coming through. If there are, feel free to reach out either now or later. Nida and I can be a resource if there are questions. Feel free to reach out. Thank you so much, everybody, for joining.
Yep. We want to thank Lerch Early Brewer for putting this together with us at Prince George's County Economic Development Corporation, and just remind everybody that we'll be doing a next session in February related to contract and contract law. And you see the little disclaimer there at the end, so I'll let you all read through the disclaimer. But just know that if you have specific questions or specific situation, you're best to get specific guidance related to your actual situation. So thanks so much, everybody. Take care, and hopefully we'll see you again next time. We appreciate you being here. Take care, everybody.
Thank you.
Thank you.